Welcome back to my channel. I am Faiz Khan, a criminal defense lawyer here in Toronto. Today we are unpacking a major legal decision that has Canada talking. The Manitoba court's ruling in R versus Nygard. Nygard was charged with 5 counts of sex assault and 1 count of forcible confinement relating to incidents alleged to have occurred in Winnipeg in the 90s. In the 41-page decision, Justice Harvey stayed the sexual assault and unlawful confinement charges against Peter Nygard. The court found that Nygard's right to a fair trial under the Charter was breached because police destroyed critical evidence from 1993. Let's go through what the judge actually said and what it means legally, and why this decision could reshape how police handles records in historical sexual assault cases. So, here's the key issue. Back in 1993, the complainant in this case gave statements to Winnipeg police. Those interviews formed the earliest version of her allegations. But, and this is the heart of the problem, those interview notes and recordings were destroyed. According to the ruling, the police failed to retain and preserve the only contemporaneous records of the complainant's account. And Justice Harvey noted that because these were the first statements ever made, they were essential to test credibility and consistency. And these are the core issues in any sexual assault trial. Without them, the defense could not properly cross examine or challenge the memory accuracy over 30 years later. So the judge framed this as a Charter Section 7 breach, the right to life, liberty, and security of the person, which includes the right to make full answer and defense. She cited the Supreme Court of Canada's 1991 decision in Stinchcombe, which made it clear the Crown must disclose all relevant evidence and the police have a duty to preserve it. She concluded that the loss of these materials created irreparable prejudice to the defense, meaning the damage to fairness couldn't be fixed by any lesser remedy. Now, the Crown argued that this was just a negligence, not bad faith, and that a limiting instruction from the judge could have cured any prejudice. But the court did not buy it. Justice Harvey said the problem wasn't simply that the records were missing, it's that their absence fundamentally undermined the fairness of the entire trial. She also criticized the lack of evidence from the Crown and police explaining how or why the materials were destroyed. The judge said there was no coherent policy, no accountability, and no justification. And as a result, she ruled that continuing the prosecution would bring the administration of justice into disrepute. And this is the only proportionate remedy uh, in this case, and that is a judicial stay of proceedings. This isn't just about Nygard, it's about systemic record keeping, and Justice Harvey explicitly said this case should serve as a warning in the digital age. The loss of critical evidence through destruction or neglect cannot be excused by outdated practices. The decision also puts pressure on Crown Attorney to prove proper chain of custody and documentation, especially in historical cases where credibility depends on decades old memories. Now, the next thing that comes to my mind, will there be an appeal? Well, the Crown could appeal, but Justice Harvey's reasoning is thorough. She found factual, procedural, and constitutional basis for the stay, and the appellate courts rarely overturn that combination. She even wrote that the state's failure here is not technical but constitutional, and this is a strong language, and this language is going to stay. There's a message every police service and Crown office in Canada should be taking very seriously, and this is not a cakewalk, and Crown's gonna have a really tough time handling such cases. Thank you guys for watching. If you found this video helpful, hit like and subscribe, and tell me in the comments, should courts be stricter about evidence retention in historical cases, or does this risk denying justice to the victims? See you in the next video.